I ran the problem through AI.
Can I pause this? Because I think this is really interesting for the episode.
Oh, yeah.
I think we should start the episode first.
All right.
Okay.
Hey everybody, welcome back to Counsel's Table. Today we have a very special guest, a first on the show, a judge. Judge Weems, how are you?
I am great. How are you?
Good, doing
How
well.
are all of y'all?
We're all
lovely.
great.
Lovely.
And if we weren't, we can't tell the judge we're not. So, yes.
Yeah, don't make it awkward.
Yes.
That's right.
Yes.
So, Omar?
Judge Weems, yeah, so thank you. You know, we have a kind of a broad category. You've seen so much over the last, I don't know, probably 6.5 years plus your private practice. But, you know, we want to talk to you a little bit about your view from the bench. Let's start with the do's and don'ts. What do you see in the high level do's and don'ts? And I know we're going to get back into it, but what do you see there?
I'll tell you the biggest issue that is coming up more and more, that lawyers are arguing against their own position, and I don't think that they're realizing it. Right? Like, I had a hearing very recently where it was weird because it was an environmental issue, so it was the county and the state against this person who was disposing of used oil, basically. And they wanted to appoint a receiver because they didn't think that he had the wherewithal or the ability to actually clean up the way he was supposed to. It literally caused a potential environmental hazard. And in arguing why he didn't need a receiver, he kept saying, well, I want to get out of this business anyway. I'm planning on selling it, and I plan on selling the property. I want to get out of this business anyway. And I'm like, well, if you want to get out of the business, I'm going to make it easy for you. I'm going to appoint the receiver, and they'll take care of this and get rid of it for you. You don't have to deal with it anymore. But I mean, like, that was literally all I needed to hear. If you don't want to be in this business, then
I own some restaurants that are doing terrible. Can you just put them into a receivership, please?
Oh, is that what you want to make your life easier?
I'm just when you were talking about that, I was thinking about my own personal woes.
Yeah,
I was just thinking of my own personal woes here.
Well, is that just, do you think people are just arguing for the sake of arguing, or are they just not realizing the end result should be just, let's do what we need to do? And
I think some people just argue for the sake of arguing. And I think, like, when he said that to me, it wasn't like he didn't think that would be something determinative. I think he was just kind of saying it offhand about how tired he was of everything. But I was like, but if you want to get out of this business, then great. Then why would you care if I put somebody else in to run it so it gets taken care of?
Yeah. I mean, it's funny to see. So don't argue against yourself. That's probably good Law 101 right there, huh?
Well, I don't think that they think that they're arguing against themselves. I think they say something and don't look at, like, the 30,000-foot view as to what it actually means. Right? If I take you at face value for what you say, then you shouldn't care what I'm about to do here.
Yeah, we actually talked about this in a previous podcast with Hunter Kraft. It's just sometimes you get in your own way, and you go in, you're so tunnel vision that you don't think about, ask yourself what else could happen. Right. And I think that's a good advice, just to come into court and what else could I say that will hurt me? But, you know, I was in a courtroom the other day, and a guy was complaining about defense counsel not responding to him. And he's like, I've reached out and he won't respond to me. And the judge said, I'll help you. He goes, I don't think that'll be necessary. They're like, how many times have you reached out to him? He's like, well, I haven't tried that hard, is what was his response. And I've never seen a courtroom in unison gasp. And they were like, not the right answer to say to the judge. Just say, I don't need your help yet, but if I do, I'll reach out to you. But it's just getting in your own way.
Yeah. I think lawyers are just not thinking about the impact of what they're saying, right? It's stuff like that. Like, I'm sure he didn't mean anything by it. I'm sure just an offhand comment, but that's the kind of stuff that when we all hear it, it sticks with us. It's like, oh, I don't think you understand what you literally just said there and what it really means.
Yes. And so do you see a lot of that, or are you seeing with all sorts of attorneys or younger attorneys?
I think the problems I'm seeing are all ranges of skill level. I mean, I think in part some of it is, honestly, I don't think the practice of law is fully recovered from COVID yet.
Why?
Because I'm still having to tell experienced lawyers who I know have been practicing law probably longer than I've been alive that they need to remember to stand up when they talk to the judge.
That's amazing
in
to
trial. Me. And you know that probably all the way up until 2020, it would have been absolutely instinctive, right? Like these are lawyers that I've gone up against when I was practicing law, and it would have never occurred, that I would have never thought that they would ever be one to say something to a judge from a seated position. But I think we can adjust to something that's like a one-off. Like, okay, we have to temporarily do things a little differently, do things over Zoom, make objections from a seated position. But when that expands to like 1.5, 2 years, that it becomes a habit. And I think lawyers are still in 2025 getting back into the habit of trying cases. And I don't know if all the judges are calling them out necessarily when they're doing stuff like that, but it's shocking to me the number of lawyers who are still like doing that kind of thing. But I say that because I think that's a part of the kind of offhand comment. Like people are so used to practicing law, trying cases, from doing depositions from like the comfort of their own living room, the comfort of their study, their office, that sometimes I think they say things without thinking and forgetting, like, look at where you are.
What do you do? What encouragement do you remind them about proper decorum in your court? Ma'am or sir, please stand.
I literally start with the whole, like literally the hand gesture of, hey.
You get some mortified, I'm sorry, Judge, because they...
Usually, but when they cannot take the hint because they're not paying attention to me, I'm just very proud about it. It's like, you need to stand.
Yep.
I have colleagues who still do the whole, if you're not standing, they don't hear you. It's almost like you don't exist.
That's amazing. We served as local counsel for someone out of Dallas in the 295th, and local counsel, we're here to make sure you don't mess up the rules and all that. And he started talking to the judge about his motion. Never stood, and it stopped everything. Stand up. I was like, I didn't think I had to be local for that rule.
Yeah. This is how you flush the toilet in Harris County.
How much do
This
you
is
have
how you wash
to
your
help?
hands in Harris County.
And I was the one saying I'm sorry, because I felt so bad. I was like, that was law 101.
You mentioned someone went to a hearing in Judge Miller's court with no tie on and no jacket on.
Yeah, it was two different people. It wasn't the same person. But yeah, it's just kind of one of those things that, how do you borrow someone's tie?
The old days, you had a jacket and tie hanging on your door in case you get called to court.
Yeah.
Current days, sadly, Zoom hearings, you have a jacket and tie and shorts to hide behind your chair, but at least go to a Zoom hearing. I didn't know you could even get through.
I like to think they're wearing shorts before that, but...
Yeah.
I might be assuming a lot.
So we gotten too casual, or we're just forgetful of the ritual?
I think it's...
Or we created a new ritual. That's an unfortunate one.
I think that might be the latter. I think people have gotten accustomed to being comfortable and have forgotten the little things. I think the fear, for lack of a better phrase, I think the fear is no longer there or is not as strong with lawyers in terms of when they show up and the decorum and things like that.
So will we be hearing of people being in contempt in your court?
Not for those kind of things, but to me, it's because it would never occur to me to ever say anything to it, As a judge, if I was watching voir dire in another court and the judge had strike sheets and I went to go get one and I still asked to approach the judge, right? And then the judge is a friend of mine. It's like, Your Honor, may I approach? Okay, to get what she's literally holding out for me. Because those things should be automatic.
There's momentary lapses which can happen through a 3-week trial, and then there's the obvious, make sure you actually stand up when you address the court.
Yeah. I think there's clear signs of disrespect and forgetfulness. Just, I think there's one, you're not caring about the rules, and you're just, I was so in the moment that I just completely forgot to do this. And you see that, I'm sure, right?
Yeah, and I think it's not helped by the fact that in Texas we have the culture of where you actually do your examinations from a seated position, right? So it's literally like you're talking to the witness, you're doing your direct, and the judge says something to you, you just kind of turn and talk to them, as opposed to the whole, sorry,
Yeah.
But I think that's kind of what's happened, because in the Zoom world, in depth, you don't
It's all
do
the
that.
same.
Yeah, it's all, we're seated, we're having a conversation.
But you let people stand up. For those of us that like to stand and pace, you allow that as long as we stay within the bounds of our little space there.
I'm in a bounds little space. I mean, because of all the mock trial stuff, I'm a big believer in letting y'all put on whatever dog and pony show you need to put on. as long as you always got to ask to approach the witness and don't get too close to the jury, and obviously ask to approach me. But otherwise, the courtroom is y'all's.
I had a momentary lapse of judgment in a recent trial wherein one of your former mock trial students, which I was lucky enough to coach, texted me and said, putting your feet on the table is a power move. I was mortified. And I emailed my wife immediately and said, you were watching, I had my feet on the table. She said, yeah, you had your feet like on the edge like this at one point when you got really casual with the witness making a point thematically, but I just lost it. Like I wasn't paying attention to where I was. Luckily, our dear Judge Lauren Reeder didn't comment on it. But yeah, but I knew to stand up, and that's why I pace, so I don't run the risk of putting my feet on the table.
It is pretty good.
Yeah,
it is a power move.
Someone's a little too comfortable.
I got a little too
I took
casual.
off my jacket.
Yeah.
There's a local rule in Dallas, not a local rule, as the judge's procedures, but it said cross-examination, direct examination must be from the podium.
Federal court.
Federal court.
Yeah, and so it's just interesting that...
One arm's length. It's the federal court. It always used to be. We were always
where
taught
can I
one
go?
arm's length. Yep. It'd be one arm's length of the podium.
That's how Judge Hind was. Everything was from the podium. That was, I think, first or second case I ever tried was in his court, and it was rules. And that's kind of... I think it also helps where you kind of started, and you started with rules, and you only know that rule.
Well, I'll tell you, a pro tip that most people don't understand with the podium, like if I'm behind a podium and that is my jury, what I always did was you put the podium to the side. Like nobody says, they say you have to use the podium. Doesn't mean that you have to be behind the podium. So that's what I always used to do is I always used to put the podium to the side of me, one arm's length away so I could literally put my hand on it while I was still talking to the jury, but it is an unobstructed view. Right, and I just look at my notes to the extent I ever need to. But
I like that. That's good to know because I don't. You hear podium, you're like, I have to stand behind the podium.
Yeah, but the podium moves.
Yeah.
Like that's the thing I think most people forget. You go. Obviously, tables don't move, but chairs move, podiums move. Utilize the space.
Yeah.
So that's the one thing that I always used to do, and that's one thing that we make sure that we teach the kids so that they know that if you have to use a podium. Move the podium to where you want it, to where it is most effective for what you're trying to do.
Yeah, and for the pacing crowd, which I'm a part of, you pace by, you flip your page, you take a quick look, and you pace away, and you know where to go back and migrate to because you get too far away.
You have your homing beacon to bring you home.
And that kind of brings up a good point to me. So I was telling them how speaking to a jury, I can speak to a wall and be fine, speak to a random group of strangers, but when it comes to a jury trial, it's like my eyes scream. And I try to remember so much. Do you notice that jurors care if you're looking at notes?
I don't think they care.
Yeah.
I think at some point, like we all do in this day and age, at some point they are looking at you less and listening more, right? Because I think we all do. I don't know about anybody else. Like when I watch TV, I'm never really just sitting there watching TV. I'm watching TV, but I probably have my cell phone. I'm probably either playing a game or looking at emails or responding to text messages while I'm watching TV.
You want my wife to yell at you too?
Probably.
That's what I do.
But we all do it. And I think now we are more, unless you are going to do something like a dog and pony show, like have a demonstrative or a board or something like that, I think most people are just going to be listening to you more than fixated on what you're doing, especially since almost every judge now is allowing jurors to take notes.
Yeah.
That, they'll be doodling or looking at, whatever they're writing on their page. And that's been the fun part. My bailiff goes through and rips out pages at the ends of trials. It's like pages of doodles and pictures and all that kind of stuff. It's fascinating how they can distract themselves even without their phones while y'all are talking, trying a case.
Yeah. So what are the tips to keep them more engaged? Or what are you seeing that jurors are more engaged with?
I think the one thing is that most lawyers don't know how to take advantage of the fact that jurors are taking notes. So inevitably kind of what we see, like when I'm watching them, at the beginning of every trial, like particularly in openings, they're writing down everything. And they're writing down so much because at the point, they don't understand what's important or not. So it's almost like they're trying to take like lecture notes in class. They're writing down everything. They think everything's going to be important. And then at some point, they're like, oh my God, we're going to be here for like 4 days. I can't write nonstop for 4 days. And so then they start writing less, and they start writing less and less and less, and to where they're just like literally they stop writing things at all. Like they won't even bring in the pads anymore. And then we kind of remind them for closings. It's like closing arguments. You might want to bring your legal pad in with you to take notes. but still kind of the same idea. They don't know what's important. And for lawyers, y'all think everything is important. So I would, when you're trying a case, particularly from the very beginning, break it down in a way to where, and be mindful of, you want to broadcast to the jury what they should be looking for. Like, I think that's what not enough people do with their opening, right? It's not everything under the earth. It's sure, it's a preview of your evidence, but like, look, I think if you ask most lawyers, their case can whittle down to like just a handful of pieces of evidence, right? Tell them, I think in your opening, it's like, these are the few things. Like, look, it's a complicated case, lots of issues, but ultimately, every case is a simple case. And these are like the 3 or 4 things that you need to be looking for and keeping your eyes out for, right? Write this down. It's A, B, and C. And like, when you tell jurors to write things down, you know what they do? Because they don't know any better, they will write it down. But when you don't tell them like what to focus in on, they just start off writing out everything, and then they get tired and they just stop writing anything.
So you got a good witness on the stand. You can actually predicate the question with, for those taking notes, tell us about.
Yes.
Yes.
Highlight the things that you think are like the key things, or like some of the effective closing arguments I've seen are when lawyers are like, you know what, for like this breach of contract case, right? You're gonna wanna look at exhibits 12, 15, and 17. We know we're throwing a bunch of exhibits back at you, but those are the 3 key emails that you need to look at that show that there was a breach of contract here. And I don't think enough people really do that. They just like vomit all the information out at them and hope that they were taking notes about everything you were saying. But I mean, like, if you're closing, even if you're closing for 15 minutes, 20 minutes, that's a long time for somebody to just write down everything. And if you've already been in trial for 3 or 4 days, they start getting to the point where, like, they listened to it, they heard it, they're not going to write it down because they're listening.
Is
right?
the biggest missed opportunity you see is the failure to connect? Is that lawyers acting like lawyers and not acting like jurors?
Exactly. I think that's a great way to put it, because I think, you know, we always worry about like, oh, golden shoes. You can't put the jury in the shoes of either of the parties, but that doesn't mean that you can't, in your opening and closings, talk to the jury and communicate and tell them what you want them to do in a way more direct way, right? Look at this exhibit. You know, this is the number, right? Because usually, I mean, think about even your most basic car wreck trial. You're sending back a bunch of exhibits to them, all of those medical records and bills, right? They're not going to want to look at all of those pages of medical records and bills, but if you tell them, look at Exhibit 5, the pages 10, 12, and 15 on Exhibit 5, that's going to show you, like, that's what I'm putting up. Like, you put them up for them, like, during your closing arguments, but you need to tell them where to find it and tell them, write this down, so when you want to go look at this document for yourself and look at the whole page, this is where it is. There's nothing to say you can't do that, and I think that, in terms of missed opportunity, is something that I don't think enough lawyers do. Tell them what you think is important so that they know, I'm going to write this down, because I think that's what jurors lose sight of the most, is what's important in a case, because y'all make it sound like everything's important in a case.
And that goes, you know, you talked about being like casual and decorum with the courtroom, but it's almost like with the jury, you got to put the legalese away, the people aren't focused on the science, they're focused on just connecting a little bit of what's important.
Yes.
But the science they care about has got to make sense.
Yeah.
And it's got to be, I mean, it can be
simple,
forensically important for your case, but it can be in a demonstrative fashion presented to them in a way they're going to appreciate.
Yeah.
I mean, technology, the old days. You get some people that come in with laser shows and fog machines, and you're like, that isn't the case for that. And you get other people that completely miss the opportunity to explain something. Like surgical animations, I think, are fabulous. 2 minutes showing how it works, particularly in the nature, duration, severity proofs we have to have now and evidence. Show them what it is. It's 2 minutes, and it explains the whole thing. And it's not just CSI jurors that we heard about 10 years ago. It's easy.
I will also say this. The one thing that we get from jurors the most is y'all do fabulous demonstratives, and the jurors always want them when they go back there.
Yeah.
So do whatever else. See if you have found a way to get in evidence, because it's almost always like when you do some kind of, when you're taking like a bunch of, financial data or economic data, right? And you do it in a chart so they understand. You got to do either one of two things. You either got to figure out a way to get that into evidence, or tell them, great opportunity for you to write this down. And if they've got a legal pad, there's nothing to stop them from doing that.
They just want to pull out their phones and take a picture.
Yeah, definitely can't do that. Because you know what we do? I don't know if y'all realize this, but when they start deliberating, my bailiff takes away all their phones and sticks it in a bucket.
Good.
They don't have their phones when they're in there deliberating.
That's nice, because you know how many things you'll Google?
I know.
Just everything.
Yeah, you know what Omar does right before every trial? He does a Photoshop of him, racing a orphanage out of this fiery house. So in case the jury Googles him, he's a hero.
I call my 100 closest friends and say, click on this link so it just gets to the top. No, that's actually really interesting. But, those demonstratives, figuring out how to get them into evidence would be great. Because if the jury's way smarter than anyone gives them credit for, and they focus on things that we never focus on.
And they don't have confirmation bias because they haven't sat with your case for 2 years on your desk. The biggest insight I've got from me kind of switching sides was I got so confirmed that I was right, because I wrote a report 2 years ago. I sponsored it 6 months ago. I wrote a pretrial report 3 weeks ago. I'm right. And then now I'm having to reflect on it because I know what the other side's doing. I'm like, no, man, y'all are missing it all. Well, the jury even more benefiting from them because they don't know anything.
Yeah.
And what are we telling them? Never heard of the story. They're in a church pew for 6 hours. You've handcuffed them with no cell phone. And then you're going to go up there and talk about stuff that you think is important to them without really considering what's important to them?
Those Harris County chairs are pretty nice, though.
But that's why, we always, when we teach, because Will coaches mock trial at University of Houston with me, and when we teach them, I always tell the students, you spend, in their world, a month with a problem is a long time. And the problem's usually anywhere from 70 to 200 pages. I always tell them at some point, your spouse, your significant other, or friend, take them for a beer, sit with them over dinner, whatever, and tell them about the case that you're working on, and then ask them to ask questions. Because that's what I used to do as a real lawyer. I would grab a friend for a beer, tell them about the case I'm working on. It's like, this is my case, right? This is my position. This is what I think the other side's going to argue. Let me ask you this. What do you have questions about? And inevitably, they will have questions about something that I did not even think about. Oh, well, so what about this? I'm like, oh, crap, I didn't even think about that. And it starts, it's I call it the cheap and easy focus group.
Yeah, totally.
Because a beer is a lot cheaper than paying some of these companies. But the effect is still the same. Person who knows absolutely nothing, coming in blind.
And it just goes to show you can be as prepared as you want with the file, but these are 12 strangers.
Oh, yeah.
They don't care about the things you care about, which is it's just mind-boggling sometimes because you have that bias, and it's fun. So I'm sure you've seen it all the time where there's right over their head, or they're like, "This is you're telling me things I don't need to know."
Oh yeah, they usually when I talk to them, because I go talk to every jury after we get done with the panel. So this should comfort all of you, in that I've never talked to any of my jury panels who I thought did not take the job very seriously, as much as they hated being picked. And you could see it on their face when you call their name and they've got to gather up all their belongings and stroll into the jury box and they all look miserable. By even day 2 or 3, they've all clicked and they're all hanging out with each other. And even if they disagree, because I've heard them yell at each other before, through the walls, but it's because they took their job very, very seriously.
Which is it would be so fun to sit back there. We were talking about that with Pipkins.
I didn't know how it worked. I didn't know how a jury foreman was selected. They just draw lots, vote. Somebody says they want to do it. I don't have a clue.
It depends on the jury. Sometimes it's they look at the guy who's been talking most, and they'll look at that guy. It's like, oh, well, we've been sitting around here for 3 weeks. You talk more than anybody else. You're going to be the foreperson.
It's always scary when the person wants to be the foreperson. That's the person I get worried about.
You read too many John Grisham books and watch too many John Grisham movies.
I did watch that Juror number 2 recently, which was really...
I saw that too.
It was pretty good.
I was pleasantly surprised.
And the voir dire comment. The gentleman who was a cop and he said, I was never asked in voir dire.
Yeah.
That jumped out at me. because you didn't ask the question. He didn't have to volunteer it because it wasn't apropos to what was asked during voir dire. He said, they didn't ask me what I did in my prior life. The florist or whatever he was running the show for everybody now.
When it says
He's a former
retired
police
on there,
officer.
when it says retired on that juror card,
Always have to find out.
What
the
did you do
retired,
before?
The not applicable, the nuns are like, yeah, so you say you don't have an occupation, but either what did you used to do or what kind of work are you looking to do?
yeah.
How long do you give? Central casting, 4-day trial on voir dire. You're, as a former trial lawyer, probably more accommodating to time than others.
We're like 45 minutes to an hour. I think that you
Per side.
Per side. I think you need to have some time limits on it.
You do.
Right? Because I think if you just kind of give everybody, it's like, however long you want. I'm like,
Lawyer's a lawyer.
Right. It's like you find a way to just expand to fill the amount of time I've given you.
Yeah.
So if there's an unlimited amount of time, it's like, it's lunch. These people are not paying attention to you anymore. Are you done?
PowerPoints, if it's not obviously talking about the facts of the case, but general acclamation on certain elements that are limited to 3 or 4 slides, good, bad, ugly.
I don't think jurors mind PowerPoints. I mean, from my perspective, if y'all agree to it, I don't care. Like, that's my role, I think, as a judge, is I'm only here on the things that you disagree about.
I think scaled questions help because they don't remember them or you got to repeat it or they don't know the scale.
Yes, with scaled, and if you have a jury panel of like 48 to go through, they forget like what's one.
Yeah.
But again, shrink the scale. That was one best piece of advice I ever got from a lawyer with a county attorney, actually with the DA's office, was like, scales 1 to 4 because there's no middle.
Yeah.
Right? And that basically gives you the strongly agree, disagree, strongly disagree in a numerical setting. And I was like, fair.
Because how many people would pick 3 out of 5?
Right?
Yeah.
So.
Be right in the middle.
Tommy was telling me he finds that jurors love getting repeat video over and over and over during trial.
50-minute cuts.
Play it all the way through, no actual dead air space.
I tell you.
Is that a mistake? I mean, because obviously it's a mistake, but the lawyer's concerned because appellate counsel's telling them, hey, we got to lay the predicate, we got to get everything in, we got to get causation, whatever it is. And I was in a case recently, I said, if y'all show another video, I'm going to withdraw right here, right now. They're done with it.
Yeah.
It doesn't matter, and the evidence doesn't matter. Like, get it in and get gone, right?
Yeah, I think if you absolutely have to do a video deposition, I mean, 2 hours of video deposition is just brutal. It's just absolutely brutal. I would almost say if you need to do it, if you can, it feels kind of the same, but actually is very different with it. Most of us do witnesses over Zoom, by all means, right? I mean, like, it's still on a screen, but at least that gives them something way more active to look at.
In your court. And I'll say the problem is now, post-COVID, is doctor availability for trial. They're not free, and you're taking away from their private practice on both sides. This is a plaintiff's defense show. And then, hey, great, yeah, I'll be there. It's $25,000, and if you don't get reached, you ain't getting it back. And that becomes a problem in certain cases because it's client's money. It's the client's money. It's the client's money on both sides. So that, I think there's a need to have a little more maybe doctor video than we'd like. I think they're much better live than on video. But you'll allow Zoom by agreement or motion?
By agreement.
Okay.
Like I said, I'm only here on the things y'all don't agree to. We have the capability to do Zoom. If you guys want to do it, I've got it set up. I live stream all my trials anyway, so have at it.
But if I were opposing counsel, I would be strongly inclined to not agree. And then what's the situation?
Why? But why?
But obviously I agree, but I'm not. A lot of people aren't as nice
Because you
as
also
me.
get to cross-examine them live.
Yeah.
And if you think it's some bum witness and, hey, man, you want to bring them by Zoom? Bring them. I can't wait for it. Let's go.
Yeah, I think most of them would rather want the opportunity to have that still real cross-examination, the gotcha moments, as opposed to playing the gotcha moments that occurred on deposition, where at that point the entire jury is just kind of glossed over, right?
Do they start paying attention to the video? Because I don't look at juries during trial, but do they start paying attention and by the end they're just like completely tuned out? I mean, I would think, Judge Mahaffey and Beaumont used to have a rule. It could be half an hour and that's it, no more. And that's a little silly because I know that sometimes.
No, but some of my colleagues have that same rule. I think what y'all don't think about when you do depositions is like when you're trying a case, you get inflection, right? Like you get to ride the energy and the momentum. So like when you're doing your cross, your cross can build some excitement, build some movement to it. But when you're doing your deposition, it all kinds of comes out the same way, and it all kind of comes out sort of flat.
That's funny.
So when you cut it together, you don't have those builds. So I think it's harder to focus and pay attention. Like you can with your voice show, like I'm building to a really big cross point here. And you do that when you're live in trial because you've got an audience. In your deposition, you don't do that. You just make the point, right? And so when you cut it together and you show them, it doesn't have that same energy. So when it doesn't have that same energy, the jury hears it the same way they've heard, state your name, what's your occupation, let's talk about your educational background.
We had a trial in front of your colleague, Tanya Garrison, and she mentioned to us, after 1,000 times, I think the jury knows that Apache Construction built the pipe bridge because every single piece of evidence came in. And she just reminded us, if y'all need to go back and recut this stuff, I'll allow it. I know this stuff was due a month ago. Clean it up. Less is more.
Exactly. But I mean, I don't think people do like I feel old, but like in the good old days, and we used to actually take trial depositions.
Yeah.
Right? And I think nobody really does trial depositions anymore. It's just like, we're going to do a discovery deposition, and then we're going to cut it for trial. But at least when you did a trial deposition, you already know what you know, and then reorganize it, and then, I mean, I understand it's expensive. But I think that when most people are doing depositions, they need to be mindful of, this has the potential to be cut, to be played for a jury. So we need to give it some variation, some movement, so that it just doesn't all sound the same, because it does all sound the same.
And then on the other side looking in, when you cut a depo and you have to hear yourself ask a question, you're like, what was I thinking? You know, like, and that's the best question. You know, that was a question I got what I needed from, but it was like, it sounds terrible. And I agree with you. And I just think sometimes it's inevitable to have to put but I agree. If you can get a trial deposition knowing, here's my 20-minute cut, straight through, I bet it sounds a lot better than the choppy face change, position change.
Or think about this. If you kind of know the points, like get a lot of the basic information out, and then I would do that at the end of your deposition, that's when you really do like your cross points, where you can actually do it with some momentum, and it's all, and not just kind of sprinkle it all in throughout. Right? Like, do the discovery deposition, but while the camera is still rolling, do your cross, or do, like, you know what I mean? Like, that way you've got a cleaner bit at the end. You just got to make sure it's not duplicative of everything that you've already talked about and done.
Well, I think there's opportunities on our side, I said the plaintiff's side, to train wreck a trial depo the defense wants to take, because when I do my cross, I'm going to call that person adverse in my case, and I can call some predicate and some qualifications and a little bit of the good stuff. And then I get to play my cross before you even call your witness in your case in chief.
Yeah.
I can do that.
Yeah, there's nothing to stop you.
Cross noticed it in your witness in the case.
We've done it. It's very effective.
Yeah.
And then you get a second bite of the apple if you need to.
Yeah.
So, these are all good practice tips, and you've seen so much, and I know you've been through a lot, and with trials.
Been through a lot. It's like, oh my God, it's been traumatizing.
Yeah. Well, I'm sure there are some traumatizing moments in your court.
I was a trial lawyer before I took the bench, and the hardest part is watching lawyers who aren't as skilled or aren't as comfortable try cases.
You don't see that a lot.
It's the whole range. I mean, it's one of the best things we do. So I live stream all my trials so my students can watch them. And their biggest gripe is whenever they go to tournaments, they're always told the same thing by judges. It's like, oh, you're 90% better. You're better than 90% of the lawyers out there, right? And they're like, okay, whatever. And I'm like, literally, go watch a week of my hearings, or go watch, 4 or 5 trials, and you see that they're not lying to you. And I think that the hard part about it is there are so many lawyers who don't do the real trial training while they're in law school. So they're figuring it out, trial by fire, literally in trial. And the part that literally keeps me up at night is that there are some people who are practicing their trial skills the same way my students are in class, except for they're doing it with a real client next to them who's either trying to, recover sums of money, stay out of jail, the whole range of things. And that's what they're practicing on. But that's what it is. It's the practice of law. That's how we learn, right? We learn by doing it. And it actually saddens me a little bit. That's why I
You said my students several times now.
Yes.
So when Christine Weems is not doing 3 hours sleep at night, she is a mother, a spouse, a district judge, a teacher, a mock trial coach, a professor, and also dabbles in a little play management as well.
Yes.
And
theater management.
And a mountain runner.
Yeah.
I'm running down the mountain.
Hey,
yes.
you're still
That's
running.
harder.
Yeah, it
Actually,
is harder.
it is.
Now,
Right
harder
on
on
the
your knees,
mountain.
yeah.
Sucks.
Oh, yeah.
Actually, that's what I'm doing this weekend. I'm going to Portland, Oregon for the Hood to Coast. I do it every year.
Oh, is this the one where you guys pick each other up, sleep in the van? And,
Yes, it
oh,
is.
man, that's intense.
200 miles. You start halfway up Mount Hood. You end up at Seaside in Oregon. It's 200 miles. It's 2 vans. It's 12 people. We'll be on the race course for somewhere in the neighborhood of like 32 hours.
It's incredible. Judge Weems told me about this, and I don't know how you do it.
I am the worst. I
I want
don't
to know
train.
why.
I don't know why
actually-
you do it.
So you know what? It's 'cause
How?
I never played sports. Like I never played sports growing up, and this is like the closest thing to like a sporting event. There's a sports team that I've ever done, and like I can't play baseball. I'm super short, so I like can't shoot a basketball for crap. But you know what I can do? I can always run, and so that's when I started doing it because I used to do 5Ks and like half marathons, and every once in a while I subject myself to a full marathon. And then randomly out of the blue, literally 10 years ago, social media, man, it's a dangerous social media. A buddy of mine that I literally hadn't seen since like my senior year of high school was like, I got into the Hood to Coast. Any of my friends who are runners want to come do this? And I was like, when you say runner, what do you mean? Like, I like to run on
Lowercase
occasion, right? But I'm not like super hardcore or anything
I
like
have
that.
legs.
He's like, no, anybody. Because the way they used to do the Hood to Coast is that you would mail in a check for the fee, which is like $1,600. You mail in the check, and you knew you got in if they actually cashed your check. So he had been mailing them a check every year for like 3 or 4 years, and finally 10 years ago, got in. And then, but like he didn't have a team, so it's like, all right, who wants to come do this with me? I'm finally getting to go. And so we've been doing
It's like
it
some
ever
of
since.
Omar's law school applications. They didn't cash the checks. They felt sorry for him. Like,
Yeah,
this
but-
kid's got no
Wah,
chance.
wah.
Can you send the
Here's
check
your $100
back?
back.
So, but yes, I literally only run like once a year, and I do this. I used to run like a couple half marathons a year, but now I just do the Hood to Coast.
Tell us about
200
mock
miles.
trial.
What do you want to know?
Tell our audience the benefits they would have if at one point they participated in for the young vintage in law school that watches this, or the lawyers that would be willing participants judging. Their 3 hours of CLE, they get a year, but giving back and the importance of helping is much more important than 3 hours of CLE.
So I'm the director of mock trial at the University of Houston Law Center, which is been
Newly ranked, by the way, or higher
no,
ranked.
no, we've
Yeah.
been going up in the
Higher
rankings.
ranked.
Way higher ranked.
So no, it's I give back to mock trial in large part because I am grateful for everything it has afforded me in life. I used to be a very shy, wallflower kind of person.
No one believes that.
Yeah, no, but like totally true. The idea of speaking in front of a group of people was the most terrifying thing I could imagine when I was in high school and probably through a chunk of college. Like I used to tell people, the way that I am now with just anybody used to be the way I was with just my friends. Like you had to know me. I had to be really comfortable with you for you to see this. And then because of mock trial, I started doing mock trial because I joined a pre-law fraternity when I was at University of Texas, and they started a mock trial competition, and all my friends were doing it. And I was like, all right, if y'all are gonna do it, I'll do it with you guys, but I don't know what the hell I'm doing.
Do you want to be a lawyer then? I mean,
I knew I wanted to be a lawyer.
Okay.
I thought I was gonna be a transactional lawyer.
Okay.
I literally had no interest in
I did
litigation.
too, by the way.
Right? How misguided we were in our youth. I never thought I would go into litigation because I thought I would just be a transactional lawyer, sit behind a desk, look at contracts, and do that kind of thing, and never actually be one to go into a courtroom because the idea of talking in front of people petrified me. But I started doing mock trial, and then, you know, it's a little bit like it's a safe environment, particularly in law school, because you do teams of 6. You do 3 attorneys and then 3 witnesses for each side. So it's a bigger team. And I was with a lot of people, and we were all the same age. Like, literally, we were all freshmen, and so we were all trying to figure it out together. One of them had done, like, high school mock trial. And so I literally remember somewhere, like, my sophomore, maybe junior year. Because also, with college mock trial, you do one problem the entire year. So, like, you really, really work on it.
You know
really
everything.
practice.
Yeah.
Right. But you keep doing rounds, and so you make your mistakes, and so you don't make them when it comes game time, because you run it through so much. And I just remember sometime in my sophomore year, my junior year, I was like, what is the absolute worst thing that could happen to me if I just told the F up and say the wrong thing and lose an objection? I want to keep going. Right? And like everything else, I'm going to remember my F up more than anybody else in the room is, because they're all in their own heads, focused on their own thing. And so, like, once you start realizing that, it just becomes a lot easier. It's like, okay, well, all right then. And so then I started doing it in law school, and then this is what I mean, like, it literally was like the turning point of everything. Because I graduated law school, and you know how it is, you just don't get to go to trial that much. And so then I started doing theater, because Houston has the 4th largest theater community in the country. And I was like, I need to be in front of people. I want to, like, you know, have that kind of audience. So I just started auditioning for stuff. And I just started doing a ton of theater, which is why now I also, in my spare time, run a theater company.
And you got a part in Office Space.
Spare time is the most hilarious phrase when it comes to her.
We'll give you a little plug there.
I was an extra in Office Space. You see me walking around in the background.
That's so cool. Though.
PC love letter.
Yeah, like, it's a movie we all grew up with, and that's just really cool. And so when I found that, I was like, I gotta go. You know, I gotta go find that.
You know,
scene.
you laugh about that, but it's literally when I'm, like, campaigning and people are ignoring you because there's like 3 million judges out everywhere. Everybody's like, I'm a judge, I'm qualified, blah, blah, blah. I was an extra in Office Space. That's what caused them to turn around.
That's it.
And, like, you were, and I'll pull out my phone and I'll show them, because there's a great still frame of, like, where I'm literally standing right behind Milton at the end of one of the scenes where they introduce the Bobs. And I'm like, oh my God, that's you. And I'm like, yes, that is me. And that is what people remember about me when I'm doing all of that running around campaigning thing than anything else, is that I was an extra in Office Space. But to go back to the point, all of that, the theater stuff, like I did a 5-year stint in New York, but that was because of the theater stuff. All of that was because of mock trial. And I just am so grateful to the lawyers that actually spent so much time with us. And I had so much fun doing it, and I love teaching, that I initially coached at South Texas right after I graduated. When I lived in Manhattan, I spent a year and I coached over at St. John's. And then
It's got a really good team, by the way.
I was at St. John's, was a very good team. Way after me, but a very, very good team. But, like, when I first moved back to Houston in 2010, I reached out to Dean Treese, and just, you know, so many people love doing that. It's hard to get in once you've been out. And so it just, because it said everything comes around. My friend Ruth, who at the time ran the intranet for the University of Houston Law Center, knew, because I talked to her about, like, what I was doing in New York, and she knew that I did mock trial, introduced me to Jim Lawrence, who was the director of the advocacy program at U of H. But at the time, the woman who ran the mock trial program kind of had the program on lockdown, so if you weren't one of her students, she didn't really want you involved. So I did ADR for like 3 years, and then she left in 2020, and that's when I got the job as director of the mock trial program. We've been off and running for, like, literally, I just finished my 5th year, about to start my 6th year running the program. So what I would have to say to people, the advantages of judging, I think, are huge, because I think when you're doing it, you don't realize. It's kind of like what you were saying about confirmation bias, right? It's like you've worked on your own case for so long that you forget about what it looks like from the outside. It's kind of like the same thing when you're judging students, right? When you start watching them, you identify all the tics that you probably don't even realize that you have. And it just makes you more conscious of, oh my God, do I do that? And it starts to make, because we can't help but do this. When you judge students, you judge them by what you would do in that scenario. I think it can't be helped. We all do that. It's like, okay, if I were trying this case, how would I do it? Or if I were doing that director cross, where would I stand? How would I do that? And I think it just helps you sharpen your skills because it makes you think, in the scenario, how would I try this case? What would I do? That sort of thing. And so I think it helps you kind of keep sharpening those skills because we don't get into trial. Y'all don't get into trial. I call you to trial, but y'all don't show up because that's why I'm here right now. I couldn't get a case into trial this week. But yeah, I think that's one of the advantages. And for me, like, because I don't try cases anymore and haven't tried cases in 6.5 years, I miss it so much that how I fill in the gaps and keep my skills sharp is by working with the students and the mock trial team. Because unless you're constantly trying cases, honing your skills, you forget. Like I tried a couple of cases and then I went to New York for 4.5, almost 5 years. And when I came back, I wasn't trying cases immediately. I was doing Hurricane Ike litigation. And when I went back into PI practice and started trying cases, I got nervous all over again. Because then you're like, oh my God, I forgot about like how you argue motion in limine. I forgot about how you do that. It stops being automatic because you don't do it for years or a chunk of time. So I think mock trial is kind of like how, for me at least, I kind of keep my skills sharp. And for all the lawyers who don't get to go to trial enough, it's how you can keep your skills sharp because you're watching other people do it and providing feedback to them.
Yeah, so how can it help? Folks that are watching that are trial lawyers, non-trial lawyers, what can they do to help the University of Houston, South Texas, Texas Southern trial?
Well, that is the great thing. We have three programs in Houston, right? And they all have mock trial, moot court, and ADR teams. So like if you're not a trial lawyer, but you are more of a transactional person, well, guess what? That's a lot of what ADR is, the negotiations, right? Same thing with like moot court. You know, they always need people, even if you're not necessarily an appellate person, if you have a heavy motion practice, you know, they need somebody to watch them and give them feedback to point out when they've got these little ticks. It's judging tournaments because there's always tournaments going on throughout the year.
They always need judges.
They always need judges. They always need licensed attorneys. But we want more than just licensed attorneys. We want people with some skill and understanding who've been in a courtroom, right? Like I know for a fact there is a alternative dispute resolution triathlon that University of Houston is hosting at the beginning of September where they need judges, and that's judging a negotiation, client counseling, negotiation, mediation component. And I'm sure most people are like, I don't know how to judge a client counseling. Like, how do you judge client counseling? I'm like, very easy. You watch it and you go, wow, why are you asking some of the weird stuff that you're asking? Or why are you doing that, right? It's kind of like, you know when they're doing something wonky when you see them do it. So even though you may not think about like, well, I don't have a whole lot of experience in client counseling, you know how you need to behave when you're trying to get information from your client about a case and the kinds of things you would want to know, right? And that's kind of what you're looking for, right? Are they asking adequate questions to get the information that they need to figure out like kind of the aspect of this potential client's case or not? But they always need people to judge tournaments. They always need people just to judge scrimmage rounds, right? All of those. So if you don't, I'm sure all three schools and all three programs would love to have, you come coach if you have more time and work with a team and get them ready for competition. So.
I think coaching's great. I'll interrupt just one thing, is that comment you made about how I can translate from mock to real is that I was helping you coach a very skilled national trial NTC team, and you were scrimmaging against a team from Denver. And I was doing it by Zoom, and the person who was asking the question in a motor vehicle problem kept referring to the vehicle as the family vehicle, the family vehicle. And I wrote it down because I've deposed 1,000 cops, I've deposed 1,000 reconstructionists, and I've always used the word passenger vehicle or passenger car. And I told myself, I'm never using the word passenger vehicle ever again. That's the family vehicle. Yeah. Because it's psychology of the family vehicle in a damages case as a plaintiff's lawyer, hell of a lot better than passenger vehicles. So on a Saturday afternoon at 12:30 on Zoom, I change the way I'll ask questions in every case going forward. And it's, that's one anecdote of something more meaningful than that. But yeah, for those that have time to help.
And I think that is the case because, it's like everything else. You learn kind of by doing. Well, even when you're helping these students with their mock trial problems, having that kind of thinking outside the box, I was talking to some students about jury selection. A great way that I've started thinking about bias, if I ever start practicing law again, is, what you're trying to weed out are basically single-issue voters, right? And that's another way to look at, that's what we're talking about, strong bias. Are you so strongly biased on this one thing that it blots out, you don't care about the facts of anything else? The way some people who are single-issue voters, right, with this politician, all they care about is that you're either pro-life or pro-choice, and I don't care your position on anything else. Once I hear that you are pro-life, done, that's it. Or once I hear that you're pro-choice, done, that's it, right? It's kind of like the same thing of what you're looking for when you're talking to juries and bias, right? I mean, because we always talk about the pie eating contests and that sort of thing, and we all have our analogies. But that's one I'm like, I can't wait to practice.
I know whose PowerPoint you're talking about.
But that's one. But now I'm like, what? But for me, that resonated. It's like because we were just kind of thinking about different ways to describe bias. And I was like, it is like the single issue voter, right? And
you
that's
teach
all
a
they
voir
care
dire
about.
class too at U of H.
I do.
Is that every semester or is that once a year?
Just in the spring. I teach a class in voir dire in the spring. Mainly because I did so much mock trial. Voir dire was the one thing I graduated law school where I felt like I didn't know how to do it. And so the first time I went to go voir dire in a PI case, which is their car wreck, I was like, what do I need to do? My boss was like, just ask questions. I was like, okay. And then I got objected to continuously. It's like, that's a commitment question. That's a commitment question. I'm like, I'm just trying to ask some questions here.
Don't you want to pay this man?
Yeah. Right? But I mean, it's like, that's what I didn't learn how to do. So that's why I teach, because they're required to do a lot of experiential learning anyway, right? Like practical skills that we do. I teach trial ad in the fall at U of H, and then in the spring I teach a class in voir dire where we literally do talk about all the cases, but talk about the psychology, talk about note-taking, I even bring in a consultant every year to talk to them generally about, what do you use consultants for? Why would you call one in? What do they do for you? What are they looking for? How can they be helpful? So they kind of get the whole wide gamut of stuff with regards to voir dire. Now, like in Texas, the Texas American Board of Trial Advocates every year for the last 3 years, this will be the 4th year, they do a voir dire tournament where literally they bring in people out of the community, they pay jurors to come show up, and the students one of them will do a voir dire, and then their teammate will do an opening statement.
You'll love this. Earlier today, we talked about what Tommy Kherkher does. He does stand-up comedy every once in a while. He said that's a really good way to kind of get yourself ready for trial, and it's just most synonymous, he said, for
I
what
think
he
it's
thinks.
awesome. You should make your students go to Tommy's Club and do a 6-minute set, improv, to get them.
Let them know what
the
failure
nerves
may
off.
feel like. That
Yeah.
it doesn't, but it doesn't matter if you fail
Right.
there,
Until you put somebody in the audience who heckles you the entire time.
which will be us.
Which happens.
No doubt it happens. I actually know a couple of lawyers who do stand-up. One of my students, Michael Dede, he's in Austin now, but he still does. He did stand-up while he was in law school. He still does it. He talks about his time because he used to be a teacher before he went to law school. He's freaking hysterical, but that's how he's constantly working on material, constantly doing stuff, but that's kind of how he keeps that skill sharp. But I agree with you. Like, if you survive that, then everyth's easy.
Yeah, that's why I think mock trial is so important as well, because it gets you just a comfort level is one thing. Whether you know your facts, every case is different, but just getting comfortable speaking to a jury.
Did you do it?
I did a little mock. I did more moot, and moot was hard.
So
Moot
confused
was
you with an academic appellate lawyer at some point?
I don't know what they did that for, but moot was hard. It was just it was just interesting because you're so focused on this brief that in case law, and that's not my style.
What's the mock trial competition that you host, probably with some colleagues on the bench, for young Houston lawyers? So it's not a law school project; it's baby lawyers.
No,
I shouldn't say baby lawyers, younger vintage
but
lawyers.
But it is. So 3 years. The last 3 years. So this will be our 4th year. At University of Houston, we've been doing Battle of the Bayou. It's a young lawyer mock trial tournament.
I'm a licensed second year. I've taken a few depots, but I want to mix it up.
It's for anybody who is licensed 5 years or less, who has fewer than 3 first-year jury trials.
That's cool.
That is cool. That's a great great thing to have.
Well, because that's, again, the problem we were running into is we spend all this time with the students getting them ready to go try cases. And then they go out into the practice of law, and you know what they don't do? Try cases, right? Particularly if they go to like kind of bigger or like big law, they're never going to try cases, or they're seldomly going to try cases. And like I said, if you don't do it, you lose the skill. The nerves start coming back. You forget about little things like, what all do we need to talk about in housekeeping? Where do I need to stand? What does my capsule for my motion in limine look like? Like, how do I'm going to package the case? So, but on top of that, it was like, that was initially when we did it, it was originally like a tournament for the young alums, because like you graduate from the program, you need to keep practicing, and they weren't getting into court. And then a bunch of lawyers were like, well, can we send our young associates, because they didn't do any mock trial, so they didn't get the skills while they were in law school. But we don't want to give them this. We don't want to give them this, $2 million, client on this big case, because they don't know what they're doing yet, but they need some avenue to practice. I think that was a great thing. When I was coming up, I worked at a personal injury shop where we had it was predominantly car wrecks, PI cases, but we had the whole range of size of cases. And they weren't afraid to just give me the file and go, all right, you're going to go to trial. So I got a lot of experience. I mean, I think I tried 2 cases my first 8 months being licensed, when I originally worked for Rob Kwok the very first time, right after I graduated law school. I think a lot of these firms now, they're going to trial a lot less. And when their cases are the ones that they take to trial are worth so much more, that they are scared to put them in the hands of a baby lawyer. So that was the reason why we opened up the tournament to anybody in Houston. Actually, I have some students who actually come in from like Austin and Dallas, like some of my alums come in for the weekend to do it. But that's because they can't get the experience anywhere else. And that's the thing. It is a way for them to get experience, comfort in a courtroom, experience trying a case, feedback.
I think it's great.
Because that was the other thing. You get because you still have the law firms who will throw in baby lawyers to go try cases, like the good old-fashioned trial by fire. But you would see them go try cases, and they don't know what they've done wrong or right, and nobody went with them. It's like literally a baby lawyer was like, here's the file, good luck. And so they could win the case, but they don't realize that they won the case despite everything that they did wrong. Right? Nobody was telling them, oh, you should have done this or this.
Yeah, sometimes a lawyer can be so bad they're good.
Right?
The jury feels bad.
The sympathy factor is real, right? But I mean, that's the thing. Like, you don't know why you win or lose a case. Really talented lawyers lose cases, and it's not because they were bad. It's just because the facts were bad. They didn't like their client, whatever, right? So you have these baby lawyers who are winning and losing cases, but not knowing what they should know from it. Right? Because there's not somebody over there watching them, giving them feedback. It's like, when they kept objecting to you making commitment questions, this is what they meant by that. I would have loved to have someone to explain to me commitment questions when I was doing it my very first jury trial. Right? So, I mean, we don't do the voir dire piece of it, but I mean, that's kind of the thing, is that you get real practicing lawyers, because I also have the limit where if you're going to come judge the Battle of the Bayou, you've got to be licensed longer than 5 years. But that way they can 2 rounds on each side, get some real feedback, and then we do a semifinal round, final round. I mean, it's been great. There have been firms one firm actually let their team, because they had never tried cases, neither one of them had ever tried a case before, like neither one had done mock trial. They actually worked with them during working hours, and they billed the time to the firm so the associates could get credit for the time that they were spent learning this, even though it wasn't being billed to any particular file.
Well, that's not. I mean, it's great that they're doing
that's the
that.
way it should be.
Yeah,
it's not the way it ever is, except for
no
that
kidding.
example.
But I thought it was great because
well, you took it serious. I mean, I know some people think it's awesome, and then because life gets in the way and it doesn't count for academic credit and they're not getting paid for it, it's probably some folks that phone it in.
And no one's life is at stake,
Right.
Yeah,
or
when they buy in by their firms, it becomes much more meaningful.
Like, they're learning real skills.
Yeah.
And we're putting them in real courtrooms in front of some real judges judging them, so that we want them to have the full experience and understand so that we don't have to keep reminding people you need to stand when you are talking to a judge, right? And when we are yelling at them about it, it's in a non-recourse environment. So, look, that's how we brought it full circle.
We apologize for not standing during this podcast.
It's fine. You have really comfy couches, so.
Yeah, it's easy to sink into, right?
It is.
Yeah.
I sleep on that couch, for sure.
They're both going to stand up now and fiddle on the
Yeah,
couch.
like, thanks a lot, Tommy. One last thing I want to know about. We talked about trial so much and mock trial, but motion practice and just hearings in your courtroom.
Or trends related to objections.
Yeah.
You know, are you seeing objections being overly used or underutilized?
I've not noticed any difference or change with regards to objections. I think that really skilled lawyers use objections a lot less, and unskilled lawyers tend to just kind of try to object to everything because they don't understand why something shouldn't come in. Right? But I wouldn't say that there's been a trend where I'm seeing people object more or less than before. We're having this discussion. I think more and more people are. I'm seeing more people not being a little bit more diligent in terms of their case preparation so that people are being able to make objections that are more meaningful. Like, I'm seeing more and more objections with regards to undisclosed expert opinion. I think a lot of times we would have just kind of let it slide, but some of the things I think people are keying in more, that this thing that this expert is saying is A, actually an opinion and not a fact, and B, never previously anywhere in the report. And so I feel like I'm seeing more of those objections, and every time I get one of those objections, the first thing I will literally just ask the lawyer, it's like, all right, great. Show me in his report where he said this before. Show me in his deposition where he said this before. If they can't find it, I'll strike the opinion, we just move on. So, I mean, I think that's one, I would say, where I'm seeing more and more of that. Like, people are more cognizant of that.
Interesting. So, I mean, that is kind of hard to have right on the spot. Are you just taking a recess for them to get that information, or?
Well, no, I don't recess. Literally, I'll just leave the jurors in the white noise for a little bit, and it's like, all right, just show it to me.
That's why you better be right.
Yeah.
If you're going to object, say it's unfounded and big, long speaking objection, which are nonsense, and I won't go on a soapbox about that. But as a trial lawyer, I don't do them. Because I think if you're wrong, a jury hears you be wrong. Just say objection and lose and go down the road. But yeah, I had a recent case, and someone judged new opinion, and we had a 5-minute recess. Show it to me. And it was there, and then jury came back in, and we picked up right where we were, and they knew exactly what happened.
Yeah.
So you better be right. Yeah, just because you don't like it doesn't mean it's objectionable. Is that correct?
Yeah. Understatement.
You know, and we talked about being less prepared. We were kind of starting this conversation before the podcast, but are you seeing, the use of AI in practice right now?
Like, here's the thing. I think people have always talking about that AI is being utilized and you just don't realize it. And so, I mean, why? I would have no reason to know other than I literally had an instance very recently where it was a summary judgment where there was a motion, a response, the reply was filed, and the reply was filed like the day or two before. And when I called them in, immediately the non-movement right off the bat, it's like, Judge, there are things you need to know before we even get started about the reply that they filed. And it was that, like, literally it cited 6 cases, but none of the they were real cases, but none of the quotes from any of the cases were actually in the case. And it was a quick search because one of the perks of being a judge is I got access to Westlaw now, and I haven't had access to Westlaw since like law school. So I pulled out Westlaw, and like one of them was a DTPA case, and I pulled out the cause, and I actually did a search for DTPA, and it did not show up anywhere.
Oh, that's...
Or like one of the cases, the pin site was like on page 42, but the case ended on page 41. It was like, oh my God, like I would like to believe because of the horror of the moving lawyer that she did not realize that this had happened, right? But like, it floored me because it would never occur to me like just to blindly rely on technology because you already hear the horror stories about like
they're out there.
They make up stuff, and we already even if you don't read the article, you can see the headline where it talks about like lawyers sanctioned for using AI that invents cases and all that kind of stuff. I mean, that's made mainstream news. And so to me, it's shocking that anybody would not double check any of that stuff. But I think it's starting to happen more and more. I was literally just at a conference this weekend where they were talking about AI, and one of my colleagues at a different law school basically said, if you're not using AI to prepare your cases, you're already behind the curve. And I was like, well, what do you mean by that? And I think the effective use of AI is like if you kind of already know the argument you want to make, right, you can utilize that to provide you alternatives to kind of fine-tune it and make it prettier, make it fancier, make it more formal. I think when most people think about AI in its use, it's kind of like load all the depositions in and have it spit out a crop, like you did when you scrimmaged the students at one time, right? Because Will did a scrimmage where he literally like loaded up the entire problem into, what was it, ChatGPT?
Yeah, I just threw it in chat. I gave it a prompt, and it wasn't because I was so ill-prepared. But it was.
How was the script? Is it good?
It was C to B minus worthy on factual compliance with a problem. Enough in a scrimmage that I can make enough stuff up anyway. But yeah, it gave a head start, and you can give it a prompt. What are the discrepancies in the problem? What are the discrepancies in this particular witness versus these documents? And it'll find them. And that's where, I mean, to me, citing a brief without pulling the cases and verifying is legal drinking and driving. We know better than that now. Yeah. We just do. Mm-hmm. But this, let it hit a single for you or even a double for you, a stretch single, and getting the benefit of that, give me some insight I don't currently have, is a whole different use and a proper use.
Oh, yeah.
And a mock trial problem, once the kids sit around and we can do it in ours. What are we doing? California? You gave me someplace cool this year, right?
National Civil Trial Competition.
In LA?
LA.
There we go.
It
will allow some enhancement, and I don't disagree with your colleague. At some point, that's just one more freebie because it takes 2 seconds to load it in and throw the prompt in.
Mm-hmm. And I think that's the thing is, as opposed to like having it generate necessarily your content for you, which is what always makes me nervous. It's like the idea of a computer, but it's taking like you already know like the points you want to cross on, but you want to figure out a way to reword it, make it better, right? Make it cleaner, or like if you have an idea like. We could all say profits over people over and over and over again, but is there a better way using these facts we can say 100%. Profits over people to where it either resonates more based on these facts or something like that? So
prompt what to ask a sitting judge on a podcast hosted by 3 yahoos, and then you'll get a bunch of information that'll come out.
2 yahoos.
2 yahoos.
Office Space. Always go fall back on Office Space.
Oh,
I was also in an episode of Law and Order as well as 30 Rock as an extra.
Wow.
I was in New York. It was great.
30 Rock love it.
Fun.
Yeah. This is very, I mean, it's very insightful to hear, just tales openly and candidly. And I just can only imagine the horror on that lawyer's face.
And that's what I mean. Like, that's how I knew, like, it was not intentional. Like, she didn't kind of come in with the idea that she was going to pull the wool over the court's eyes.
You got 3 kids. I didn't know that could happen versus I got caught.
Right.
Yeah.
It was definitely not one of those. She was absolutely horrified by it. But at the same time, it was the first time for me as a judge that I actually it was right there. And I was like, oh my God.
And you had a courtroom full of lawyers, didn't you?
Yeah. That's kind of awkward.
Well. Such as, I mean.
C'est la vie, my friend.
Hey, like you said, you remember a lot more from the mistakes you made than. And no one's going to remember her as that person. Maybe you might, but
I mean, it's like I said, it's the practice of law. It's how we learn. It's kind of a brutal lesson to learn. But, it's like you were saying, we all know better now. I mean, there are enough horror stories out there where it's kind of like, maybe you just need to double and triple check everything.
Oh, yeah.
And even if you don't have resources to Westlaw, I mean, like with the state bar, there's, what is it called?
Fast case or
case text or something.
Case text. Yeah,
but they've got bare bone. Like if you put in a case, it'll pull it up. Yeah. Or even if you just do a good old fashioned Google search.
Google Scholar will have cases. Every Southwest case is there.
Yeah.
Pop it up real quick.
It's nice. I mean, AI is becoming helpful in the sense like, we were talking about it at work the other day. You might know a holding. You just I know there's a case that says this, and AI has become pretty helpful in telling you what case that is. Like I can tell you what the conclusion was, but I have no idea what the case name is, and it's helped.
I mean, don't get me wrong. AI still scares the crap out of me, just in terms of like what it means for the future of humanity, mankind. But
You know, it's funny. We've been talking kind of generational when we did a younger lawyer thing, and it was now, you know, like we always make fun of the older generation. They didn't know how to open a PDF, and now it's like I refuse to learn AI. You know, I'm like I don't want to do it.
You're in your
And I was
fancy
like,
fax machine.
Yeah, I'm like it's just one of those things. You're like, I see how things get. You know, they kind of go down the
yeah,
No, but
the
moot court,
vintages.
mock trial, Tron cases matters. I was listening to a very well-received podcast, your friend, Bob Simon, Bourbon Proof, and they were commenting that AI is going to allow intake through resolution on the pre-lit side with no human involvement at all.
Yeah.
But you're never going to replace people that got to stand in front of 12 human beings and try a case, ever. Well, I'd hope not. Not anytime
12
One
soon.
would
AIs.
hope.
Yeah. Yeah.
One would hope.
Yeah. That's
Yeah.
why, litigation,
Yeah.
career in litigation. Sign up for mock trial and judge if you're a lawyer.
The judging's fun. Sometimes you feel a lot of pressure on the judge. You're like, well, I feel some good points, but you're also not coming up to I'm coming up with a verdict here.
I'll
So
editorialize a bit. And one reason I'd want our audience for seasoned trial lawyers to participate more, it's a better competition when judges can give meaningful feedback. And no disrespect to a more juvenile or a transactional or real estate lawyer. If you're judging a mock trial criminal problem or a civil blood and guts problem, having someone that does that for a living, I think, is a better opportunity to have a better representation on the judging side and the outcomes. And you're not just, hey, who's got cooler tie on, because you know it. So I would encourage those of us that have that experience to participate.
Yeah, I did the screaming chicken last year. That's a fun one. That's just a good problem. She actually, whoever's in that scenario, I forget the name, the plaintiff, but she showed up on my Facebook friends recommendations.
It's because when I write problems, it was we recycled a problem that I wrote for the very first Battle of the Bayou, the Young Lawyer Tournament, and that year I named everybody in the problem after like my very first class of students.
Yeah.
So Emily Luco is a real person.
Thank you, Emily Luco. Yeah, she popped up and I was like, why do I know that name?
All
And
the
I was like,
judges'
do I know this
ex-boyfriends
person?
are in the problem.
So that was just a good little thing I meant to tell you about that.
That's random.
Yeah.
Awesome.
Take us out.
I think that's it.
Yeah.
All right.
Well, thank you for your time,
No,
Judge
thank y'all so
Weems.
much for having me. Appreciate it.
Awesome.